Hearing. The Court of Appeals of the State of Indiana is now in session. The Honorable Ezra H. Freelander of Hamilton County is presiding with Honorable Elaine B. Brown of Du Bois County and the Honorable Rudolph R. Pyle III of Madison County. You may be seated.
Morning.
Morning.
We're here this morning on Gresser versus Dow Chemical. Mr. Pardick, you've had 15 and 5. You're ready to go. And Mr. Jefferson and Mr. Johnson, good morning. You may proceed.
Thank you, Your Honor.
You may also assume that we've read the briefs. You may also assume that we've done our homework, so we don't need to know the facts particularly, I think, in terms of extraneous facts. We understand we'd like to get to the issues because there's only 20 minutes aside.
All right. And, Your Honor, I was only going to discuss the facts to the extent that they relate to a violation of FIFRA. The violation of FIFRA has an impact on whether or not the rebuttable presumption is at play here. And the FIFRA violations go back to the belated reporting of 288 adverse incidences in 1994. That caused Dow to be fined and for the EPA to file a complaint seeking sanctions. There
was a settlement in that regard, wasn't there?
There was a settlement, that's correct.
How does that relate to the punitive damage issue?
Well, the filing of the complaint, I think, shows the EPA state of mind, that this was something that they considered to be a violation of FIFRA. The payment of the fine, it also shows notice to Dow that there were significant adverse incidences that were not known to EPA nor to the general public. And so I think...
When did the settlement occur? Give me a time framework in which the settlement occurred, those things occurred, when this incident occurred, and how that applies to the punitive damage issue today.
The complaint was filed in 1995. The settlement occurred shortly thereafter. That set off a re-evaluation of the registration of TC. And in 1997, that led to an agreement between Dow and EPA to begin to restrict the use of Dursban. Negotiations continued. There were...
that case is the only evidence to support, by clear and convincing evidence, willful or wanton conduct. Is that your argument?
That is not the only case. There's considerable other evidence. That is the only case filed by the EPA. The EPA negotiated a final agreement to phase out and withdraw the product, Dursban, in 2000. The negotiations went on for some period of time prior to that, and it was known in the industry, as our experts have testified, that this product was coming off the market.
Was there any rule or order issued by the EPA telling Dow to do something that Dow did not do?
Well, there was not a rule or order that I'm familiar with. There were memoranda to Dow and to the public disputing what Dow was claiming in its publications and in its advertising.
But at least under administrative law, in order to require a party to do something, you're either going to need a rule or an order, right, in order to get them to do something.
There was no rule or order, apart from the fines that were levied back in 95 or 96. And subsequently, the order calling for it to be phased out was finally entered in 2000.
In your brief, you list 4 items, the allegations. Dow failed to warn and instruct about Dursban, failed to warn about the risks of long-term impairment and other things that you listed right there in the beginning.
Yes.
Are any of those items that you listed in your brief required by either state or federal law?
I think they are required by state law because those are things that a reasonably prudent and careful manufacturer would do in promoting a pesticide that is poisonous to be used in a home. They would have told their applicators, for example, that this was a highly volatile product and that if it's placed in a...
You used the word would. Just now, you just used the word would. They would have, which causes me to think that this is more of a policy argument you're speculating about something, that there's not a statute, there's not a law, rule, or order that says you need to do these things. And I'm trying to get to basically ask you, what in the record is there that would show that Dow violated either FIFRA, a state law that was in compliance or in line with FIFRA, or something like that?
Well, the complaint that I referred to initially shows a violation of FIFRA. And the violation consisted of failing to advise EPA of adverse incidences, which included...
That's the EPA complaint you're referring to.
That's correct.
Not your complaint.
That's correct.
Okay.
The EPA complaint.
Go ahead.
And traditional Indiana tort law would require that a manufacturer advise the EPA, its applicators, and the public of the dangerous, unreasonably dangerous nature of this product, one of which is that it is highly volatile. Applicators didn't know this. It wasn't.
Is there anything in the record that would show that the label, there was misbranding or anything about the label?
Well, the misbranding, we contend, comes from Dow's use of a resource manual that was given to the applicators, telling them more about the product than was on the label, and assuring them that the product was safe, that it had been tested for humans. There were publications in there, something called Outlook, and in another publication called Common Talk or something like that, where they said that this had been tested extensively on humans, and it could be used on carpeting, and after it was dry, children could play on the carpeting, all of which was proven to be untrue by these belated, withheld adverse incident reports, and which EPA took issue with repeatedly, and this was really important in causing them to negotiate this agreement to take this product off the market and to phase it out.
After the settlement, did Dow ask the EPA to make any changes, to allow changes to its labeling requirement, to its label?
They did not ask for the label to be, they did not allow ask to be permitted to continue to use the label. In 1999, there was a modification to the label, and that label was continued to be used for roughly a year or until it was phased out and taken off the market.
So what change to the label was made? I mean, was it, did it contain warnings about the use of the product, or what change exactly was?
It did not contain warnings about the use of the product in residences. And this is what we're contending, that Dow should have taken note of the adverse incidents that were reported, the memoranda that came out of EPA where they were complaining about it being used in residences around children, and they should have and could have issued advisory notices or other publications telling their applicators that of the hazard of using this in residences where children were likely to be present. Ultimately, this issue was resolved by the EPA in having the product come off the market.
Is there anything in the record that Dursban was not properly registered under FIFRA? Or is that something you would concede, that it was properly registered?
I would concede that it was properly registered initially. Knowing what, in retrospect, knowing what Dow knew or should have known at that time, the labels, the warnings in the labeling was inadequate. And so the registration of the product became inadequate, at least with the passage of time, and there was no effort by Dow to upgrade the label or to improve the warnings or the instructions to the applicators. But I guess directly to answer your question, at the time it was registered, so far as I can't contend now that it was improper.
if it was properly registered, would they be entitled to that rebuttable presumption? Under
They would
product
not.
labeling?
They would not be entitled to a rebuttable presumption because it did not comply with FIFRA. And it did not, and that became evident when the complaint was filed by the EPA. And it alleged violations of FIFRA. Dow acquiesced and agreed to that and paid this, what at that time was the largest fine in history levied by FIFRA. And so the violation of FIFRA alone disqualifies their use of a rebuttable presumption.
And so your view would be, because of this agreement and settlement, that creates a genuine issue of material fact that made the trial court's order erroneous? Am I understanding what your position would be?
I'm sorry, I didn't hear that question.
Your position is that Dow did not comply with FIFRA, and you're using this prior complaint and settlement and agreement as supporting your position.
I'm using, yes, I'm using that, but I'm also using the history that developed after that violation and the literature and the adverse incidences that were reported that show that there were violations of FIFRA in that the warnings were inadequate, the instructions to the applicators were inadequate, knowing what Dow knew as time passed, and so those were violations of FIFRA as well. So that they cannot claim that they were in compliance with all applicable codes, standards, and regulations.
Is the agreement with the government in the record?
Yes.
And all of the other documentation that you're referring to is in the record?
It is.
Can you just tell us briefly how the Pliva case applies to the case as you see it, to your case?
The short answer is no, I can't tell you that briefly, but I can say that
You only have 20 minutes.
Pliva was, of course, a different statute, and it did not have a provision allowing, calling for an express preemption. And it was a case that involved a generic drug that was required to use the FDCA warnings that had been approved and the label that had been approved. They did not have the ability to change the label. There was a requirement of sameness for the generic manufacturer that it had to use the same label and warnings that were developed by the original manufacturer. With pesticides, that is not the case. The pesticide manufacturer drafts and designs its own labels and its own warnings. It is not bound to use anyone else's. It has the right and the ability and the duty to change that label and to modify the warnings and instructions as facts develop that show that those changes and warnings become necessary. And they can do that by going to the EPA, and the sections of FIFRA indicate that if they need to make a change in the label, they can make that change and then notify EPA that they've changed it. And the EPA shall approve that change so long as it is not in conflict with other provisions of FIFRA. So that Dow had the ability to upgrade their warnings and their labels to take into account hazards and dangers that were well-known, becoming well-known to everyone at EPA, and they simply didn't do that. Now, with Pliva, the generic manufacturer was simply limited in its ability to.
What about the manufacturer in Pliva? Was the manufacturer in Pliva in the same position that Dow would be?
The manufacturer, well, the statute is a little different in that the manufacturer would be in the same position in that they could have changed their label. Yes, I guess in that respect, They are in Dow's position.
The statute might be different, but the supremacy clause referred to in Pliva remains the same. Majority in that suggested that the notwithstanding language in the supremacy clause, they use some fancy Latin term, but the notwithstanding clause suggests that any state law that conflicts with federal law makes it impossible for a manufacturer to comply with the federal law. I take it you disagree with that holding.
I agree that the supremacy clause does make that, require that. However, FIFRA has a provision that says that the state may regulate the sale or use of any federally registered pesticide or device in the state, so long as the extent of the regulation does not permit any sale or prohibited or use prohibited by this chapter. So that Section 136 VA differs from the FDCA statute that Pliva was under.
Your position would be that that's Congress's way of signaling something different under FIFRA than the FDA or the Food and Drug Law.
Yes, that is a difference. Thank you.
Thank you, Mr. Pardick. You've got 5 minutes. Mr. Jefferson, Mr. Johnson, I don't know how you're going to split it up, or if you are, but you're up.
Yeah, Your Honor, and may it please the court, my name is Paul Jefferson. I'm pleased to be here on behalf of Dow AgroSciences and the Dow Chemical Company. Judge Pyle, in answer to your point, there's nothing in the record. Plaintiffs have pointed to no rule or regulation in FIFRA that Dow AgroSciences has violated, so the rebuttable presumption applies. And Judge Brown, in answer to your question as to what the revisions of the 1999 label were, they're found on page 1460 of the record, and they include ingredient statements and precautionary statements revised. So any issues related to the 1995 settlement are resolved in terms of what the label contains.
But opposing counsel said they didn't explicitly contain warnings about application of the product for residential uses.
And we disagree, Your Honor. And of course, under Indiana law, the warning provision of the Indiana Product Liability Act deals both with instructions and warnings. And the label is almost exclusively consisting of instructions on how to apply the product, both in pre-construction residential use, post-construction residential use, based on the foundation that's at issue in the home. And that's, the label contains a lot of things, but the bulk of it are the precise instructions that the licensed applicator must use in order to properly apply the product. And plaintiffs themselves in this case concede in this summary judgment stage that had that been done, the aggressors would not have been harmed. And that's the fundamental issue in this case. Since the day the complaint was filed in March of 2004, we were going to hit a fork in the road. Either the instructions were going to be adequate, or the plaintiffs were going to have evidence that the instructions were not. And the plaintiffs simply have no evidence in this case that the instructions that the applicator should use are inadequate or defective. In fact, the plaintiffs argued just the opposite, that had the applicator followed the instructions approved by the EPA, approved by the Indiana State Chemist, and included in the label, then there would be no harm. And that is the central reason why summary judgment should be affirmed in this case.
What is the state law provision that you claim conflicts with FIFRA?
Well, I think plaintiffs would read the Indiana Product Liability Act in a way that would conflict with FIFRA. And the easiest way to answer that question, Your Honor, is that if Dow AgroSciences did what plaintiffs would have us do, it would be a crime.
I want to know what site, what statute do you believe, or case, or something, because that's what Pliva uses, the language, state law, that conflicts with federal law. What state law does your client believe FIFRA conflicts with FIFRA such that it would be impossible to comply with federal law?
Well, there's no state law. What plaintiffs are saying is that using the state tort system to require, warnings in the label that the Indiana State Chemist and the EPA forbid, that's where the conflict would come into play. And so there is no conflict now. But if Dow AgroSciences unilaterally changed the label to do any of the things that plaintiffs had requested in this case, then they would be a crime. It would be illegal. And that's where the conflict arises, and that's why it would be impossible for Dow AgroSciences to do what plaintiffs would have us do in this case.
Well, then, just looking at case law, isn't the real question, has Dow complied with the law? And if you have, that's the result?
That's absolutely one of the questions, and the answer to that is yes, we have complied with the law. And you know, there are 4 fundamental ways that this case can be resolved. First, the product's not in a defective condition. And then only if it's in a defective condition do we get to the question of whether the rebuttable presumption applies. Then only if the rebuttable presumption, which unquestionably applies in this case because the product was registered, only if the rebuttable presumption is somehow rebutted do we get to the question of whether the product was misused, which the plaintiffs contend it was. And then only if we answer the question of whether the product was misused do we even know what claims exist to be preempted under Pliva. And so I think that analytical framework's helpful because we think, frankly, that each one of those elements in and of themselves compels affirmance of the judgment below.
Why do you believe Pliva is applicable to the case here at hand?
Pliva is applicable because just as a generic drug manufacturer in that case, it was impossible for them to unilaterally change the label or the design of the product. So too is it impossible for Dow AgroSciences to change the label or the design of the product.
But we're talking about 2 separate statutory schemes. If you're talking about preemption, you have to be limited to that statutory scheme. Am I correct, or are you going to persuade me to another?
I think that the preemption analysis stems from the supremacy clause, and either it's possible to comply or it's not. And here it would be.
Okay, so that's the holding of Pliva. It's about what to consider under impossibility or conflict preemption.
Correct.
Okay,
Implied
so
conflict preemption.
We're not talking about generic drug manufacturers or anything. We're just taking the holding in Pliva about impossibility and then applying it to these facts because
Correct.
The statutory scheme means nothing because we're talking about a totally different statute.
Well, I respectfully the statutory scheme and whether things are possible or impossible do parallel each other in many respects.
Does FIFRA have the same preemption language, statutory preemption language, as the Food and Drug statute in Pliva?
As it relates to the impossibility issues, the answer is yes. FIFRA also has an express preemption provision that the statute in Pliva did not have, but this is a conflict preemption.
That doesn't signal to you anything about Congress's intent as to one statutory scheme versus the other?
Your Honor, we know from Geyer that Congress doesn't intend a conflict. And here there would be a conflict for Dow AgroSciences to do what plaintiffs would have us do.
But food and drugs consumed by people are different from things designed to kill termites, yes?
Yes.
So Congress could completely mean something different under that statutory scheme versus FIFRA, yes?
They're designed to accomplish different policies, but the possibilities of compliance to achieve those different policies either exist or they don't. And here it would be impossible for Dow AgroSciences to comply as the plaintiffs would have us do. And as Mr. Pardick was talking, he indicated that, he seemed to represent that we could, as the manufacturer, just simply submit revisions to the EPA and they would automatically come into effect. Nothing could be further from the truth. And if you want to know the exact place in the record where this is discussed, it begins on page 1777. What Mr. Pardick cites to is a regulation a statute that Congress provided to the EPA that it may allow certain changes to be made by notification. And in public pesticide registration notice 9810, which is at App Site 1777, all of those issues are set out. Which issues can be changed by notification and which issues can't. None of the things that plaintiffs allege needed to be changed on the label could be changed simply by the manufacturer saying we want to change it. It requires notice and comment. It requires all the things that Pliva says makes it impossible. And so that's why those statutory schemes parallel one another and the possibility and impossibility provisions apply. But again, I want to reemphasize the point that we only get into the preemption analysis if there's a claim to preempt. And here, there is not. The warnings and the design in this case are simply not in a defective condition. And plaintiffs have admitted this. They've admitted this by saying if the product were applied as the label instructed it to be, the aggressors would not have been harmed in this case. And they have to make that choice. This isn't a alternative pleading type arrangement. It is the fact of one.
So you're throwing Reliable under the bus.
I think Reliable has very compelling arguments related to summary judgment and trial, particularly as it relates to causation. And the facts of this case are, and I'm certainly not suggesting that the product was in fact misapplied, but what I am suggesting, as the Ford Motor Company versus Reed case says, is that under Indiana law, you have to disprove everything but a product defect. And here, plaintiffs haven't only failed to do that, they've proved that something other than a product defect caused their injuries, the alleged misapplication. Now, whether or not a duty exists based on the facts here, where the product was applied in a vacant home that was moved into a year later, and whether or not there's, what duties arise as a result of that is a question for Reliable to answer, and I think their arguments, frankly, are very compelling on the issue. But as it relates to the Product Liability Act and whether the product is in a defective condition, clearly I think plaintiffs have come to that fork in the road.
Your colleague argues that all of these complaints about adverse effects of Durspan are relevant to going into what you're just talking about. Can you comment on that?
Sure, and I'd like to talk about the 6A2 issue a little bit. The first thing I'd like to say is, as I mentioned earlier, if there were anything associated with that caused a change in the label, the plaintiffs are the beneficiary of that change in this case. The label was revised in 1999. That's the first point. The second point is that plaintiffs would link the 6A2 issues to the ultimate decision, the memorandum of agreement, that ultimately led to no more residential uses of the product. And that simply cannot be. In their brief, they don't cite to the reason, which is Congress's, the Food Quality Protection Act of 1996 required the EPA to re-register every pesticide and to apply a completely different risk analysis and an additional safety factor in doing so. And that's what caused the non-residential use of this product. Now, chlorpyrifos is still used all the time in agricultural uses, Lorsban, for example. But in terms of, it's the Congress's change of the risk. And frankly, it simply cannot be that the tail can wag the dog in the way that plaintiffs represent. And Judge Freelander, you asked about the 6A2 issue specifically as it relates to punitive damages. I think the Philip Morris case completely resolves that issue as to punitive damages. Because, and I respectfully disagree with my opposing counsel's representation that everything related to that issue is in the record. And I would encourage you to look at the settlement agreement, which goes into detail about what we're not admitting, about the confusing state of the regulations. But understand the 6A2 issues were simply lawsuits like this one, and whether those lawsuits had to be provided to the EPA. So under the Philip Morris analysis as to what's fair under the due process clause, all of those litigants have already received any damages they're entitled to as a result of that process. So then to bootstrap the 6A2 issues to a punitive damages argument simply can't hold water, even if all the other issues didn't attach.
As it stands right now, Dow is out on all counts. Is that correct?
That's correct, Your Honor.
And Reliable is still in only on the negligence claim. Is that correct?
That's correct, Your Honor.
All right.
And Your Honor, again, I want to discuss a little bit some of the specific issues. All of the warnings, the label is adequate as a matter of law. And I think Judge Hall recognized that this is fundamentally a warnings case and not a design case. And the procedural posture, I think, dictates that. And all of plaintiffs' design arguments simply don't hold water under a long line of authority, which includes the Bourne case, the Bunomatic case, and the Crossman case that we've cited in our brief. You simply can't use another product to show that there's some sort of a defective design. And the quote we use in our brief is, as the Seventh Circuit said, if that were the case, then the existence of a Volvo would render every Kia defective. And that's what plaintiffs try to argue here. But I think their arguments on the defective design piece inform the analysis under the warnings piece. In their brief, they go into detail, and Dr. Parker emphasizes this. In the brief, they go into detail about different products and different warnings, all of which the warnings are required and analyzed and approved and dictated by the EPA. But the warnings in this case that's where the case begins and ends. And it's the instructions that are included in the warning, as 3424.2 says. It's the instructions that are included. And the instructions, when applied in this case, clearly the plaintiffs would agree. The plaintiffs have agreed in their brief. If the instructions were complied with, there would be no harm to the aggressors. And so those warnings must be adequate as a matter of law. And Your Honor, in conclusion, unless there's any additional questions, I want to leave some time for my co-defendant, Mr. Johnson. But at the end of the day, there's no defective condition in Dursban TC. The presumption against preemption hasn't been rebutted. There's been no pointing to any regulation or rule that the Dow AgroSciences has violated. The product has, by them, allegedly been misused to the point where it would be a defense and summary judgment could be affirmed under the Saturn case. And finally, if any claims remain, they're preempted by Pliva v. Mensing. Unless the court has any further questions, I'll turn it over to Mr. Johnson. Thanks.
Mr. Johnson. It's the all J team.
May it please the court, Lonnie Johnson for the defendant and appellee reliable exterminators. This case perfectly illustrates the difficulty that plaintiffs take on when they try to maintain simultaneously a variety of actions against Dow, warning, defects, design defect, and also claims against my client, Reliable, for misapplication under service contract. I'm going to argue the point that we make in our brief, which is sort of the opposite of what was just made by counsel for Dow. We believe that the attempt to show a design defect against Dow in this case has undermined their ability to carry their burden of showing specific medical causation against Reliable. And what we mean by that is their design defect, they claim that the Dow Dursban with chlorpyrifos is inherently volatile. They actually, Mr. Pardick said here today that even applicators are not trained on how volatile it is. That's one of the theories they have against Dow.
So in other words, no matter how it's applied, it's going to be dangerous.
Yeah, they say it'll revitalize and it will be distributed throughout the non-target areas, and it will leave a residue that will allow for inhalation and dermal contact. So that's their claim against Dow on design defect. And their evidence, Dr. Simon testified that even a perfect application results in quote unquote high levels, and testified when I asked him deposition, would it have caused a perfect application, would it have caused the kind of harm that they allege? He said, yes, it would have. Their biologist, Dr. Slotkin, says that chlorpyrifos has no dose response threshold, none, that it's harmful at any and all levels. That's why he justifies not doing what Hannon would say you need to do, is go through and try to give a quantification. Now, under those circumstances, I believe they can still make a case against my client, just don't believe they have in this case. I believe what they would have to do is show, Hannon says you don't have to be there, you can do modeling. They had 3 different tests from the state chemist, Karamita, and Reed Environmental. They could have come in and done modeling, and they would have had to show this, that the design defect inherent in the product means that the non-target areas would have had levels at this level, which would have caused this illness.
Doesn't all of this, it still doesn't make the trial court's order concerning your client wrong. You're still not entitled to judgment as a matter of law, am I right?
Well, I cross-appealed that I am, because not on preemption, but on specific causation. Yeah, and my thing would be they would have to go in and show that the defective design caused this levels in the non-target area, which contributed or caused these symptoms. Then they would need to show, but with the misapplication, there was an incremental exposure above what you would have with the design defect. Then they would have to show, but for that incremental exposure, the harm would not have occurred, or it would not have been a contributing harm. So I'm not arguing that they can never maintain actions against both an applicator and a manufacturer. I just think that in this case, trying to juggle a design claim, a warning claim against them, a claim against me, they did not undertake the analysis that Hannon talks about that they would need to do. And they had the opportunity to do so. They had 3 different sets of tests. For 5 years, they thought they had that. Reed had levels that exceeded the threshold limit value of the American Conference of Governmental Industrial Hygienists by 3 times. So 5 years, they thought they had that. and I thought I had a big problem. But when Mr. Eaton was deposing Mrs. Reed, she said, I forgot to convert. I converted the standard to match the state chemist, which was parts per million, but I left the others micrograms. So it wasn't 3 times. It's the closest thing you can have to a Perry Mason moment in a toxic tort case. It went from 3 times the threshold to 1/3. So now they don't have that. They don't have that first threshold they have to make against my client that there was an incremental exposure beyond what there would have been because of the application. They tried to bootstrap a letter by Blondell from the EPA, which is inadmissible hearsay, but for the sake of argument, if it got in, that would be the starting point for modeling, not the ending. What he does is he says that the hot spot, a place in the crawl space, which is part of the barrier, that one limit of 0.97 micrograms exceeds the median that were measured in 8 houses. Well, a high point, particularly if it's part of the crawl space for the barrier, is always going to exceed a median. That would be a place to start. They did not do any modeling from that would show that there is this incremental exposure that can be linked to a harm that the plaintiffs are alleging. So for that reason, we believe we should be entitled to summary judgment on all claims. Also, with remaining time, I would point out, I believe that there was confusion on the trial court's part, and rightfully so. It's a very confusing case. I believe the court believed that we had joined their motion for punitive damages and denied my motion for partial summary judgment because we didn't put any evidence in, like in Ebeling. But actually, we did put in designated evidence. We would submit that record shows this is not an appropriate case for punitive damages against reliable. Thank you very much.
Okay, thank you, Mr. Johnson. Mr. Pardick?
Your Honor, the Reed data that counsel referred to is a red herring. All of the data that was collected by the state chemist office, by people that Janice Gresser retained before she hired counsel to inspect the house, all of that data was sent to the Great Lakes Center for Children's Environmental Health. It was sent to the EPA in 2 separate submissions. That's in the record at App 4324 to 4329 for the EPA, and 4308 to 4311 for Dr. Mazur. The Great Lakes people sent all of this data, all of the good data, the bad data, the mistakes, and everything else, to a Dr. Asa Bradman at the University of California at the Research Center in Children's Environmental Health. All of that data was reviewed, and they found that the exposure was 3.9 times greater in the Ebeling home than in other homes that had been tested where there had been appropriate applications, so that there should be no mistake about what the exposure was, that this family was put at risk at a time when they were looking for a safe and secure home in which to raise their children. And this occurred because of the negligence of Dow in not advising their applicators of the volatility of the product. That's one of the reasons it is defective. And they didn't advise that this was a long-lasting poison that was going to remain in the home. Mr. Johnson referred to the, can't think of the name right now, it's a company that was hired by the Housing Authority 4 years after the Ebelings moved to go in and rehab that home. And they still found evidence of chlorpyrifos on wipe samples and in the carpeting, and they spent tens of thousands of dollars rehabbing this home. And this was in Mr. Johnson's record. So that what you have is the negligence of Dow in failing to properly instruct their applicators and in failing to warn the public and the applicators about the unreasonable dangers that are inherent in this product. And because they were not properly instructed, because the applicators were not told about the consequences of an improper application or the consequences of failing to seal off the ductworks and turn off the air handler in the furnace, they misapplied it. And it was a foreseeable misapplication. Dow had been told by the EPA that there were reports of misapplications by their applicators. And they were told that the information that they provided the applicators, that this exposure involves minimal risk, that it is safe for use. In 1999, in a memorandum from EPA, they were told that this is wrong, that there's considerable data to the contrary. So you have coming together a property that had not been adequately instructed and warned about, in which, frankly, we still say was defective in design because of this propensity to volatilize. That comes together with an applicator who apparently wasn't aware that in 1999 and 2000, Dow and the EPA were negotiating to take this product off the market. And they went in and applied it. They applied it in a careless manner. And the home had distributed throughout on the curtains and on the children's clothing and in the surfaces of tables and in the carpeting poisonous molecules that later adversely affected the Eblings and caused them to abandon this house that they had worked so hard to clean up. When they moved in, friends and family and the Eblings talk about an odor that was really difficult to live with. And they did everything to clean it up. They put in air filters. They cleaned the whole house. They changed the furnace. They cleaned the ductwork. And still at the end, when they moved out, when they invited representatives from Reliable and from Dow to come in and tell them what to do with this problem, the odor was still there. It was still there. And ultimately they were told, and you'll see in these letters from the Great Lakes people and from the EPA, they were told to get rid of everything you've got in that house. They got rid of the children's clothing, toys, furniture, anything that was soft. They simply hauled out to the dump.
Time's up. Thank you. Gentlemen, thank you. We appreciate the oral argument. We appreciate, or the discussion. We appreciate the briefs, which are very well done. We appreciate the amount of work we now have to do. The trial court said that this was confusing. We will try to make some sort of order out of all of this, and we will get you a result as soon as practicable. So thank you.
Thank you.
All right.
I couldn't understand your note.
Under that
Perry Mason,
federal notice.
I've told this story to people. They don't get this. That is like a Perry Mason.
Did you know you're on Joe's marketing plan?
Who?